This is Citizen Extra. Good morning and thank you for joining us. I'm Hussein Mohammed. Shortly we'll be getting live pictures from Parliament and specifically County Hall, where the Joint Parliamentary Select Committee on Election Laws continues to receive submissions from the public. And crucially this morning, the IEBC will be presenting its submissions on the proposed amendments that have split Jubilee and NASA down the middle, with the opposition thus far boycotting the parliamentary process. And as IEBC appears before the committee, it will be interesting to see if there will be any departure from this.
We don't need any more laws to give Kenyans an election on 26th of October. But if Parliament passes the laws, I've also said I hope those laws will not change the framework we have put in place, because if they do so, then they'll put us in a very precarious situation.
We'll be live in County Hall, where also, interestingly, the Law Society of Kenya, religious leaders and civil society organizations will be making submissions. And political parties are also expected to weigh in on the matter. Now, will NASA constituent parties send any representatives? When asked that question by our reporter, Stephen Leto, here's what NASA presidential candidate Raila Odinga had to say.
Really do not want to follow Jubilee into their madness. Those people who belong to Madari Correctional Institution. So we don't want to talk to them about those.
Well, in studio this morning, we have NASA Secretariat CEO Norman Magaya and Ndaragwa MP Jeremiah Kioni will be joining us shortly. And former IBC Commissioner Thomas Setangule, thank you so much for making time for us. This morning, we'll be crossing over, as I said. Francis Kashuri is at County Hall, and we'll be linking up with him shortly as the proceedings begin at the Joint Parliamentary Committee process there regarding the proposed amendments. I'll start with you, Norman. Political parties are expected there today. We've heard what Raila Odinga said. We know NASA's position in this. We should not expect any NASA constituent parties to send any representation.
None.
None at all.
I think our position has been very clear and consistent right from the time these amendments have been initiated. And we don't intend to change our position midstream. We believe that the process they are undertaking is unnecessary. It is ill-conceived. It's mischievous, and we wouldn't want to be part of that mischief. We don't want to sanitize that process by participating in it. So we said they can have their way to their desires as it is now, but we will not participate, either by making presentations to the forum that they are undertaking. I look at it as the worst form of public participation. Is actually a mockery to what the Constitution contemplates. So they can go ahead. There is a stage to which we are waiting for them, and we will deal with each other when it gets there.
I'll come to that shortly, but Thomas, yes. Is that the right way to handle it by the opposition? What do you think?
I don't know. I think they may have their own say, depending on their own strategy. But however, I think it's better that they were to appear before the committee and present their views as to why they are opposing this law. I think that way their voice would be heard. Maybe they have a point, because personally, as a constitutional lawyer, I also don't agree that this is the right time to bring these amendments. For the first time, I'm agreeing with him on this. But I have my reasons to back why the Constitution as currently, as it is now, is enough to cover what the law which is proposed intends to do. Therefore, I agree, probably these laws are unnecessary at this particular stage. But they should have appeared before this participation and make their point known. Maybe their voice would be heard, rather than boycotting, as they want to do.
Regardless of the numbers, of course, Jubilee has in Parliament, and that this has been supported by Jubilee leadership. I
think they should present their views to be known, the reasons why. As we shall certainly take you through, I should also be sharing with you why I think these laws are not necessary at this particular junction. Yes.
Okay. Norman, you're saying later on, and we expect this obviously to be brought later in Parliament, we will know, because we've heard from some sources in Jubilee, they are going to determine this depending on what the public has been telling them, whether these amendments will pass, whether they will come into effect immediately or after the election. That does not matter to you either way?
I think it is dishonesty from what Jubilee is saying. They are talking from both ends of the mouth. Hussein, I can assure you that that bill will go through as is, irrespective of what the public says in the forum they are conducting now. They don't intend to change a comma. They conceived them. it is only them who know what the objectives of those amendments are. So before you walk in to try and make alterations of what they are advancing, you must fit into their strategy of what they want to achieve. And since no one, maybe apart from, I can see sponsored groups that have been programmed to come and make presentations there, unless you fall into that category, and those groups are just speaking to what they have proposed, I don't think Jubilee is going to change this. And the talk that we can make a determination as to whether these laws apply now, this bill will have had transitional clauses that will say that although we are making these amendments now, they will not apply in this election. So this is an afterthought, and it's just out of the pressure, maybe from the diplomatic community, from religious leaders, that they are trying to start shifting their positions. But I can tell you, for all intents and purposes, these amendments are meant to apply in the election set for 26th of October. And I don't think, even if you participated in it, you could change Jubilee's position on what these laws are. As to having our voice heard, we are going to do what we did with the reducible minimum. We've done an analysis of that bill, and we are going to do a 2-page advert in the newspapers to state what our position is. We will rather our case, yes, we will rather our cases to the Kenyan people rather than participating in these proceedings to sanitize a process that is completely unnecessary. And the timing of it all completely raises unnecessary tension. That's why we said it was an act of extreme provocation. Today is, I think, 21 days to election. Really, the Commission should be focusing on the final details of the process. So to take them back with these amendments, because if you look at the nature and effect of those amendments, it will alter the framework that the Commission has put in place towards holding this election. And that just goes to hit a Commission that is already low on confidence. It completely upsets the manner in which they prepare for the election. Yes.
Okay, just for the record, we were supposed to have Jeremiah Kioni, MP Ndaragwa, of course, from the Jubilee Party. He'll be joining us shortly, of course, so Jubilee will have representation in this discussion. But, so let's say these laws go ahead, and you're saying you're sure they'll be passed as is, and you're saying, your words, that you're sure again that they will take effect for this coming repeat election.
Yes.
So what happens? What do you do?
That's why I've said that let them have their way now. One is that if you look at many of the provisions of that bill, there are those that are offensive to the Constitution, that cannot pass the test of constitutionality. Those will be dealt at with that at that stage. But the larger question is actually the moral question. Why will you bring amendments in the middle of an election process, just a few days to election? I don't think this has happened anywhere where people are intent on having a free and fair election. And if you look at the entire reasoning of the Supreme Court, there is nowhere in the majority judgment where they faulted the process on the basis that there was a lacuna in the law, or that there was lack of clarity in the law as to what needed to be done. And so if you look at the foundational principles in forming these amendments, that test is not there. And you wonder where Jubilee is inventing this, because they are saying we're trying to implement the Supreme Court decision.
Yeah,
but in the majority,
they're saying there's unnecessary changes.
In the majority decision, there is nothing as this. In the only decision where there was such a recommendation was in the minority decision.
They're saying the necessary changes, just like you want changes in the IBC.
I've not seen any jurisdiction anywhere where you make legislation to implement a minority decision.
If I can contribute, I think let's look at the changes that Jubilee is proposing. The first change is to look at a situation where the vacancy occurs in the office of the chairman, or there is absence of the chairman. And therefore they are proposing that in case there is an absence of chairman, then the vice chairman acts in place. And if the vice chair is not there, then the commissioners appoint one of them. Is that not what they want?
Yes.
Now, if that is the case, I think they are missing the point, because all this situation is contemplated as well in the Constitution. First, if you look at the amendments, they don't conform to the Constitution in terms of Article 250. Article 250 sets the office of the chairman completely separate and distinct from that of the commissioners. Therefore, if there is a vacancy in that office, it means then you have to advertise and the process of vetting and appointment takes place in accordance with Article 250. You cannot then change that position by trying to introduce an amendment through an act of parliament to have a replacement of chairman, substantively, as contemplated in the amendments. Number two, I think there is also a misnomer that there is something called National Returning Officer. By the way, National Returning Officer is only in the regulations of IBC. It's nowhere in any law. And now, let us look at how to cure this. Hussein, if you look at Article 138.3c, it is actually 138.3c should help them, because 138.3c says, after counting the votes in the polling station, the IBC shall tally and verify the count and declare the result. What it means is that the IBC is the commission, the entire commission. Therefore, even without a chairman, the commission can sit under this Article 138.3c and declare the result.
So meaning from interpretation, if assume, because the investigations currently going on, the chairman is implicated and he has to leave office before the repeat election, we can still do the election without a chairman.
Exactly. What it means is that it's the commission which, under this article, which shall tally and verify the count and declare the result. It's the commission. So you don't have to declare the absence of chairman, whether chairman is there or not. It's a decision. And I will tell you this, because having sat in the 2013 IBC declaration results, we sat as a commission, we look at the results, we actually held a plenary and upheld the results, and then we just allowed chairman to announce. So what it means, if there is no chairman, for example, for any reason, and I don't know, by the way, why they think this chairman will not be there, I don't know, because we have had older chairman before, Kivuitu, and such older chairman, and they still survive until the last day. So I don't know why the mischief about this chairman in this particular time. But then, even if assuming that chairman is not there for any reason or resigns, then the commission...
But it's a possibility, isn't it?
It is there, okay. And we must always contemplate scenarios. And I don't know why it has become so real now. But then...
because the investigations in the IBC and Norman Magaya and team have been calling for changes. Of course, they have not said the chairman, but you've called for changes and even removal of 2 commissioners from IBC. So it's a possibility if the investigation...
I agree with saying. But I think if you look at the intention in that article I've read, 138.3c, then it cures that anomaly which they are trying to look at. It cures that mischief, because at the end of the day, it's the commission which makes the decision. So even though I know Article 138.10, subsection 10, still gives powers to the chairman of the commission, but then if you look at the intention, it is the commission as a whole which must sit and make a decision. And I therefore think that it's not necessary really to introduce these amendments now, especially if they are being opposed by the other player. So they should just resort to what is provided in the Constitution.
We'll have a lot more to talk about regarding these proposed amendments and what, of course, will be happening at County Hall, where we'll be going live shortly to follow the proceedings. And as I told you, IEBC is expected there. Political parties today expected there to make their submissions. The Law Society of Kenya and religious leaders will be joining Francis Gashuri. For more on that, later on, we'll have this discussion again in studio. And as I told you, we're still waiting for Ndaragwa MP, who's a Jubilee Member of Parliament, Jeremiah Kioni, to join us in this discussion. Now, the taxpayer could end up footing more than R1 billion annual wage bill for assistance to members of the county assemblies. In a deal reportedly sanctioned by the Salaries and Remuneration Commission, each of the 1,450 elected MCAs is entitled to 3 personal helpers at the county government cost. Uasin Gishu is one of those counties where this has already been made public. You can see there, if all the 1,450 MCAs are to be granted this, then annually the taxpayer will pay 1.04 billion shillings. The vacancies or the offices there are ward office secretary for MCAs, personal assistant to the MCA, and ward office security guard to the MCA, meaning the secretary will get 15,000 shillings a month, personal assistant 20,000 shillings a month, security guard 10,000 shillings a month. Let me cross over now to Uasin Gishu County. John Wanyama is standing by. John, I hear you have some MCAs with you there, but have you also been, let's hear first what they have to say, of course, but have you also been able to hear from the members of the public and what they think about this?
A very good morning to you, Hussein, and here really I'm at Uasin Gishu County Assembly, and here, as you've said, people, MCS here also are demanding that they should be given some people to help them in their offices, and as you've said, the PA, the secretary, and the guard. So most of these people, the Kenyans, especially common Kenyans, the taxpayers, are the ones who are going maybe to foot for these expenses. Without wasting time, Hussein, let me talk to majority leader here in Uasin Gishu, Mr. Lugoi, to tell us why and how do they need these people in their offices. Mheshimiwa, if you can come closer to me here. My first question to you, I understand that you've not already even settled in your office. Why do you now at this early stage demanding that you need these people, secretary, PA and guard?
Thank you very much, Wanyama. First of all, I want to put this across that this staff, it is just an advert for this term of the new assembly. But even last term, we had the same staff. You know, as a member of county assembly, you cannot work from your house. MPs have offices, senators have offices, governor has an office. An MCA will not serve people, discuss issues development in his own house. So we need to have an office. And in that office, you need to have an assistant. You need to have somebody who can take minutes when you're seated. That's a secretary. Sometime when you are in the county assembly, you need somebody who can assist you run some errands for the development of the people. That's a PA, paid too little, like 20,000. Then you need a watchman to guard the property in that office, because the county assembly service board or the county government will spend money to buy those office stationaries. They'll buy computers, they'll put network, they'll put everything there. You cannot just leave that office unattended and think that you have an office. Tomorrow, if the office is broken into and those things are taken, then the government will go at a loss. That is why we are hiring a watchman. The guard is not the guard to guard the member. No, it's a guard to guard the office. That is a misunderstanding. Now that office needs a secretary, and actually you need a PA so that you can be enabled to run and do things. I want to tell you that this is a provision in SRC. SRC are allowed us to have 3 staffs. That is a guard, a secretary and a PA. Even in the last assembly, it was the same. So it is nothing new. It is just an advert for the new term members, because we are all getting into the new term or the second assembly. So we need employees because they are employed on contract. Now we need employees for the next 5 years.
Maybe someone will think that the PA and the secretary, these 2 people, is like you are duplicating their work.
The PA is my personal assistant. When I'm busy in the assembly and there is a burial or there is something that I want to do, he'll run there and make sure that he gets that report and brings it back. The secretary sits in the office, receives the visitors who come in the office when I'm not there, records what they need, and also helps me during, you know, we have quite a number of things that and representative issues that we need to be raised. So that secretary will be noting those issues, and day-to-day work of the secretary is to sit in that office. But a PA is somebody who you can call when there is a problem somewhere. He'll run on your behalf, help you get the information so that you can give out what is required at that time. You cannot work without a PA. That is.
Thank you, Mheshimiwa. And Kenyan wage bill, you can understand, is very much stretched. Do you think this is necessary at this moment?
Thank you very much. Yes, we know the Kenyan wage bill is huge, as you say. But we cannot also cripple a member from working and offering services to the people on the name of wage bill. There are some other offices which are irrelevant as compared to this. If you follow the structure of the national government and the county government, there are some positions which are relevant. But this one, we need them to serve our people. We actually need them. For us to move, for us to do what we are supposed to do, we need them so that we can efficiently serve the constituents who elected us.
Thank you very much. You said, let me talk to a member of parliament who comes from Langas, Mr. Muya. Do you think, tell us first, you have been complaining that you have not received money from the government, and some major projects are not moving on, especially in the county assembly. Is this true?
Yes, thank you, Wanyama. Thank you for that question. We know what is happening in our country right away, and we know that after the 8th election, the Supreme Court ordered the rerun of the 2 presidential candidates, that is presidential candidate Raila and Uhuru Muigai Kenyatta. And we know very well that the government have focused on other issues. Therefore, as an old MCA, I know what was happening and what is happening now. What I've tried to verify is that the COB have not released the required amount of money to the counties so that the right operation can continue. What he's doing, he's releasing maybe monies for salaries for the employees and the very essential operation money, so that because now the government, the county government have not settled. Therefore, I'm only asking Kenyans in the Republic of Kenya, let us save this country by going into the poll on 26, elect the president, so that we can settle all this once and for all.
Thank you very much, Mheshimiwa. On the same note, you have not been given money for development. Do you think these people you want to be employing them, like PA and secretaries, are they necessary for now, since the government is not now giving you money for those development projects?
Wanyama, to start a process does not mean that we are hiring them tomorrow. We have just initiated for this process. Maybe it will go for the next 1 month or 2, because they are applying. There will be vetting in our county assembly service board. Therefore, it doesn't. Maybe for the next 2 months they will not be in the office. By the time we'll be having a president in place, we'll need these people like yesterday, because somebody should not complain about our assistant in office. Let Kenyans not see members of county assembly as former councillors. I was privileged to be a councillor, and whatever I was doing then, I don't do it today. Today, Tuesday, Wednesday and Thursday, I'm supposed to be in Bunge. Monday and Tuesday morning and Thursday morning, I'm supposed to be in committee meetings. Therefore, you find that many a time I'm not in the ward. Therefore, I need somebody who can receive my visitors in the office, get what the electorate need, so that when I'm even legislating, I know what people need. Therefore, because I have only one day, that is Friday, maybe when I can meet people in my office. Therefore, on that Friday, I'll have to know which group and which group need to see me, so that there is somebody who's supposed to keep my diary. Therefore, I need Kenyans to be fair to us, because the members of parliament in the national government, they have these people. Why? Because they are not in their constituency in day-to-day running of the business. Therefore, as member of county assembly who is supposed to do legislation in Bunge, I'm supposed to have a working office which must have a secretary, which must have a PA to be receiving my visitor in my absence, and more so in these offices, as the leader of majority have just stated, we have properties for the county assembly. We have properties worth more than 100,000. Therefore, we need somebody to be guarding this office.
Mheshimiwa, it's going to cost maybe like 1 billion per year for you to facilitate and pay these workers. And for the next 5 years, you can imagine we are going to use 5 billion. And Uasin Gishu alone will normally receive 4.5 million money from the government for this county. Do you think this is really fair for us to pay only these a few people for 30 wards in this county?
Let me say this, that it might be seen to be quite a huge amount of money. But if you want to cripple the working of members of county assembly, which the SRSRM commission so that it's necessary and they gave a provision, then let us eradicate these people. But if we want to see the offices of members of county assembly working, we need to be fair.
Right, those are pictures from Uasin Gishu County. Uasin Gishu County, of course, where John Wanyama was talking to members of county assembly there, who of course now want to get more services by hiring ward office secretaries, personal assistants to the MCA, and ward office security guards, at a cost of generally, if it is replicated all over the country, 1.04 billion shillings annually. We'll talk about that more later. Let's first now cross over to Parliament, and specifically County Hall, where Francis Gashuri is standing by. Gashuri, good morning. Of course, a crucial morning before the Parliamentary Joint Select Committee on the proposed changes to the election laws key because, of course, of the people that will be coming to make submissions. There are IEBC, religious leaders, political parties, and, of course, civil society, and even the Law Society of Kenya. Kashuri.
Absolutely, and good morning to you, Hussein. Yes, County Hall is a place to be for the better part of this morning and a bit of the afternoon because it is the third day of the public hearings by the Parliamentary Select Committee on electoral laws changes that have been proposed by Jubilee ahead of the 26th October return march between President Uhuru Kenyatta and NASA leader Raila Odinga. Yesterday, some religious leaders were expected, or generally the religious leaders were expected here to come and make their submissions before the committee that is co-chaired by William Cheptumo and Fatma Dulo. But they didn't come. The NCCK, we saw them in Limuru at the Jumuiya Conference Center where they had their own proposals in relation to the electoral changes and long-term changes in terms of the architecture of the country's governance. But back to today, IEBC is expected to come and make their submissions before the committee, at least last evening on JK Live. Ezra Chiloba, the CEO of IEBC, confirmed that the IEBC commissioners will be making their way here this morning to come and make their submissions before the committee co-chaired by Cheptumo and Duale, basically to come and give their ideas or their views insofar as the changes that have been proposed on the electoral laws are concerned. Remember, IEBC is the end user of any laws related to election that will be passed by Parliament. And so it is in their interest to come and make their submissions, present their views, tell the committee what they think about the proposed amendments and whether they will in any way interfere with the preparations for the grand rematch on the 26th. So we wait to hear what they will have to say. But at least the chairman of the IEBC is on record saying that he does not necessarily need any new changes to conduct the repeat presidential election, and that all the areas that were identified by the Supreme Court as loopholes that led to the invalidation of President Uhuru Kenyatta's re-election have now been covered, and that all they need to do is to ensure that there is better verification of the results that are coming from the polling stations and do things in a more careful manner, so to say, make sure that they observe clearly all the documents that are coming from the polling stations and the constituency returning officers before they can announce or they can declare any results. So basically we wait to hear what specifically the chairman and the team of commissioners will be saying to the Cheptumo Dulo team insofar as the changes that are proposed to the electoral laws are concerned, Hussein.
By saying chairman, is that you confirming that it's actually the chair that is coming from IEBC?
Most likely, because even during the meeting between the presidential candidates the day before yesterday, at least the chairman in his briefing and that interview that he did with Sam Gituko, he was saying that they have been invited and they would be appearing before the committee today. So we want to believe that the chairman will be leading that team of IEBC commissioners to come and make their submissions today. Remember, part of the proposed amendments was saying touch on the chairman specifically because there's a proposal to change the procedure and qualifications for appointment of the IEBC chairman, as well as some of his powers insofar as the conduct of meetings of IEBC are concerned. And remember, there's a proposal to reduce the quorum for commissioners in any decision making in the commission to at least a half, but not below 3 commissioners. That is from the current plenary of 5. And so that is an important aspect of the amendments that I will be very keen to hear what the chairman has to say insofar as that is concerned. Remember also there's a proposal that in the absence of the chairman for whatever reason, that the vice chair will automatically take over all the functions of the chairperson in an acting capacity. And in the absence of the chair and the deputy, then any commissioner from the team of commissioners will be left, can take over the functions of the chair insofar as the entire process of the election is concerned. Remember, the constitution is clear on the role of the chairperson insofar as his function as the returning officer of the presidential election is concerned, Article 138 of the Constitution. So we wait to hear what the IEBC team will be saying in relation to the proposed amendments vis-a-vis the powers of the chairman as the national returning officer as envisaged in the Constitution, Hussein.
Well, thank you so much, Francis Kashuri, joining us live from County Hall. I'll be joining him shortly as the proceedings begin there. Jeremiah Kioni, MP in Daragwa, now finally joins us. Thank you so much for making time for us this morning.
Oh, thank you.
A lot already, I can tell you, has been said in your absence.
My apologies for being late.
But I'm sure you'll respond to those shortly. Let's take a look again very briefly at what Wafula Chebukati said last week regarding these amendments.
We don't need any more laws to give Kenyans an election on 26th of October. But if Parliament passes the laws, I've also said I hope those laws will not change the framework we have put in place, because if they do so, then they'll put us in a very precarious situation.
Thomas, I'll start with you. Do you expect any departure from what Chebukati said today?
Now that he's on record saying that he doesn't support the changes, I would think that he would take the same position. And by the way, as I've said, Hussein, I support that position, because in my view, and I've articulated before, the law, the Constitution of Kenya under Article 138 covers basically what the Jubilee is introducing. I think those amendments may not be necessary for now, because every anticipated situation in those amendments are already in our Constitution. And in fact, some of them are almost attempting to micromanage the Commission. For example, if you introduce an amendment to say the quorum, what are you saying? I mean, this is the first time law is introduced to even introduce issues of quorum in the Commission. I don't think they are necessary, because all these things are anticipated in the Constitution. And in fact, one of them is very fundamental. I mean, if you change the qualification of chairman from that of an holder of a Supreme Court qualification, a judge of that level, and then you give to any other person, I think that is highly responsible for us. In the Commonwealth practice all over, is that Supreme Court judge becomes the chairman of the Electoral Commission. That is the practice, and we cannot try to change that practice now. I think there is a reason why a person qualified to be a judge of the Supreme Court must head the IBC. The reasoning is that such a person understands the law, understands the reasoning, and can make judicious decisions. And therefore, to bring these amendments to water down the qualifications of the chairman, although I think it's panicky to bring that. It's not good. Okay.
Honorable Kioni, why are they necessary? Of course, this goes to what you're saying, why are they necessary?
One is that, and thank you for having me. My apologies again for coming in late. And listening to Chebukati, I don't seem to get that the point that he is saying that the amendments are not necessary.
Entirely.
No, I don't think that is the message that he was saying. He starts by saying that the laws that are in place are adequate for them to conduct an election, which is a very important thing for us here to say, that even in the event that we cannot get anything new, we will still deliver an election for the country. And then he goes to the point further and says, and I also hope that what is being put on the table does not affect the infrastructure that they have put in place, so that we still achieve the elections that we wish to on the 26th. And I think the two statements are important to me, and they help us to move forward. One is that I want to agree with him that, and I am happy to hear that the IBC is going before the parliamentary committee this morning, so that he is able to clarify if the intended amendments affect the preparation for the elections that are scheduled for the 26th. And I hope that there will be he'll be able to make useful contributions that would inform the intended amendments. Let me also say this before I even come to the answer to what you have said, that the phase that we are in the proposed amendments is this public hearing. And I would even take this to be part of public hearing, only that we are not before the parliamentary committee. So it's a very important process that we help in doing this. But Hussein, let me just say this. The whole intention is to clear any gray areas that may be existing within the law. If you think that we are being overzealous, it's because we want to get out of this scenario where we are in an electioneering mood forever. I hear what my colleague is saying, that you providing for even the quorum within the IBC and the rest are things that have not been done elsewhere. I hear him saying that the qualification of the chair world over has been those of a judge and what he has said, and I agree. But if we are in a situation where we now fear, having gone through what we've gone through, if there is any chance that the country can continue being dragged into this process, I think it is only fair that it is cleared. I do not know what it is that we would want to say in the event, an unlikely event, that the chairman is not available to announce these elections, for even the reason that he is unwell that morning or that evening, whatever time it will be. I think it is important to be clear as to what happens next so that we don't end up with unnecessary legal charges. I know you can read the constitution and say the vice chair would automatically come in. But already you have people saying, but the vice chair has no qualifications of a lawyer and the less. So it's needed to clear those gray areas. It's nothing mischievous. There is nothing bad in this. And this is why we have this public hearing, so that people can go and say and present their fears. And I wish everybody was there, including the members of parliament from NASA, because that is where you make, you can even do away with amendments if you're able to convince those sitting there that these amendments are not necessary. So I don't think it is important to read mischief in it. We should be trying to see what is it that we can do to ensure that elections are held on the 26th and unnecessary legal charges are not there on issues that can be dealt with during the process. Remember, the Supreme Court ruling talked about the need to make sure that the process is also right. And that these laws are also helping us go through that process, but also saying the process and the counting of numbers, both of them are right. And I want to say this, we in Jubilee are not preoccupied in defeating NASA, because that seems to be the narrative in many places. We are not preoccupied with that. We want this electoral process to come to an end. We cannot hold the country this way for any longer. Everything has come to a standstill. And if we are given the mandate to rule, it is to do the things that would help the country to move forward, not to rule or to go out saying, oh, we defeated who and who. No, that's not a preoccupation.
Okay, Thomas.
Thank you, Hussein. I think if I am Mheshimiwa here, right, the intention of bringing the laws was a genuine intention to address concerns which may emerge. But and he says if the law is clear, then they don't have to go through this. But then and this is the concern that I was addressing, Hussein, when I said, if we look at our constitution, and particularly, and you will allow me to read, particularly Article 138(3)(c), and I will read, and it says, after the counting of the votes in the polling station, the IBC shall tally and verify the count and declare the result. The IBC. Who is the IBC? That is the question you should ask yourself. Who is the IBC? The IBC is not the chairman. The IBC is the commission, inclusive the commission as a whole. So what the Constitution of Kenya in that article says, the IBC shall count and declare the result. So you don't have to contemplate the disappearance of chairman because there is an IBC. At least all the commissioners will not disappear. So if the IBC is in place and the IBC is the commission, and it is the one which should declare the result, then there is no need of introducing all this because it's already in the Constitution. The IBC is the commissioners themselves, and they will do that. And they can delegate any one of them to read that declaration. Yeah. So in the event that there is no chairman, it's already covered here. And I think those worries that in the event that there is no chairman, although they are valid, I think as long as the commission is there intact, they will perform their functions.
Okay, I'll come to your response. So first, let me get Norman's response to this.
I think, Hussein, what you get from explanations of Honorable Kioni, one, these amendments are based on conspiracies. Conspiracy in the sense that during the conduct of the August 8th election, there was no single moment when the
Right, pictures you can see there of County Hall. Of course, we're waiting for the first, whether it will be IBC or LSK or whoever, which interest body will be coming to present before the Joint Parliamentary Select Committee on the proposed amendments to the election laws. Let's go back to our discussion here. Norman Magai, you're saying?
So I was saying that they are based on conspiracies because on August 8th, there was no single moment or the days leading to that election when the operations of the commission came to a halt because the chairman was not there. there was no single process that was not undertaken because the chairman was not there. The Supreme Court, in its majority decision, there is nowhere they mentioned that the operations of the commission were hindered because of the absence of the chairman. It's an amendment being undertaken with the view that Jubilee has a preferred commissioner, that they would like to execute the powers of the chairman in the absence of the chairman. And I think we are dealing with a situation where there is premeditated disappearance of the chairman of the commission, and only them can tell us why they are doing this. Two, I look at these amendments as a belated attempt to mount an appeal against the decision of the Supreme Court. The Constitution clearly says the decision of the Supreme Court is final, but Jubilee is trying to mount an appeal on that decision legislatively. They're using legislative fiat to try and undo some of the things that the Supreme Court highlighted were problematic and that formed the basis of nullifying the election. So that where there was a foul, what these amendments intend to achieve is that they sanitize that event and say there was no foul here, there was no foul here. Thirdly, and I said, what is the moral of these amendments? Okay, if there were any amendments to be undertaken during this process, they could only have been bipartisan, that there are amendments that are necessary for the proper conduct of this election. But where you have one player to this election unilaterally initiating amendments, they have already conceived them, drafted a bill, and then they are inviting you belatedly to go and simply have your say on it, okay, as they have their way. It's ingenious. It is dishonest on the part of Jubilee. But most significantly, and I want to take Honorable Kion to this, the Supreme Court, in its majority decision, there is nowhere in its entirety where it says that the election was not conducted properly because there were lacunas in law. There is nowhere. They actually said in paragraph 179 that section 139 as regards the transmission of presidential election results was abundantly clear, but the commission departed from it and decided to undertake a process that was not contemplated in law. So what we are saying is simply enforce and comply with the law as it were. And even where there were gray areas, these gray areas were clarified in the Maina Kiai decision, so that the commission was faced with a decision where the law was as clear as it could be. And I don't see any reason why these laws should be amended other than for ensuring that you have an environment where any election conducted can only be won by Jubilee.
Can you respond to that? Plus, of course, what he has said and what we all know, the framework with which we went into the August 8th election, those laws were negotiated by both parties. Is there a reason why you deemed as Jubilee it wasn't necessary, or why you didn't negotiate again, or why you didn't reach out to the opposition before coming up with these amendments?
One, I think it is important, and I'm sure Bonamagaya knows because he's the one literally driving the NASA side, that even as we sit here, there is a petition that has been filed by the chairman of IEBC seeking a clarification on a couple of issues. One is on the decision of Maina Kiai, and two is even on the judgment that was delivered by the Supreme Court. And one of the clarifications that the chairman is seeking is to find out, in the event that I find there is a problem between forms 34A and 34B, what am I supposed to do as the chairman? Am I supposed to rely on form 34A or 34B? Because again, we have the same laws, or the provision, or the Maina Kiai decision saying the decision or the polls, the results as announced at the constituency level are final and can only be altered by the court. He is here at Bomas of Kenya, and he's discovered there is an anomaly between what was declared at that 4A and what he is supposed to give to the nation at that 4B. And he's seeking how is it that he's supposed to reconcile the two positions. And I'm just picking that, and he's in court on that and one more issue. And I'm just bringing that out to just try and talk to Charles Magaya, that even if we were to lead conspiracy, and I think it's important to admit that the problem in our country is that we are very suspicious of one another. everything that, even if he was to try and push that water to me, I would start wondering what is it that he is thinking. I could be reading conspiracy, even and I can see him pushing the water to me. And those suspicion levels are the ones that at times make it difficult for us to discuss and get to move on issues. The law as it is, certainly as the chairman of IEBC said, he still can deliver the elections on the 26th of October. But we as leaders also would have the responsibility to find out what is it that caused this difficulty. Is it something that we can cure by providing a clear, having clear provisions in law so that the country is able to go through this once and for all? As to how is it that we got to this position without calling in NASA, I think the thing is that this issue of suspicion is not helping us. It is, if we were able to get a committee, if NASA, for example, were able to get their committee members into the select committee that is now dealing with this issue of amendments, they will be able to get to this thing. This is just a bill, and that is why you sit together as a committee and say, given what we have had, given what we also know, this is the way that we think we should go forward. But boycotting, it is not helping at all. And I think the boycotting is based solely on the fact that Jubilee have the majority. And you fear that even what you say may not be taken into account. That fear, I don't want to assign it anything, but let me say this: it's a situation that is there. Even when I was there during 10th Parliament, and we were there with ODM and PNU, and we had to try our best and get anything done because ODM had the numbers. Yes. We never boycotted any sitting. We still managed to deliver the constitution together. But we were always outnumbered by ODM. We never shied away. And I want to encourage NASA not to shy away, not to be so scared, not to be so fearful. Let them come on the table. I believe that we have reasonable people who would want to know and understand that these are leaders elected and they have useful contributions that can make to the country. But to be on the other side and say, we can't come, nyinyi ni wengi kuliko sisi, hatutakuja, it doesn't help.
That is not the case, Hussein. It's completely wrong for Honorable Kioni to make it a contest of numbers. One, these amendments are not parliament driven. These amendments are State House driven. They are conceived in State House and presented to Jubilee members of Parliament to make it law.
Does that make it wrong?
We have dealt with this situation before. This was the same situation in December 2016 when they mounted amendments to the negotiated election amendment laws number 36 of 2016. They did the same thing. It's not the first time that this is being done. The other wrong thing.
But does it make it wrong that the government, can talk to
as he continues, even if they were Orange House driven, I will be there negotiating with them.
You see, I'm telling you that there is no goodwill whatsoever, okay, to participate in a process conceived elsewhere with an intended objective. I told you, it's only Jubilee who know what the end game of this amendment is, okay? So you cannot come in, be invited at the tail end of the process, and you are being told this is the bill we have, this is what we want. First of all, it's presented as a private member's bill, then presented by the leader of majority in the Parliament, okay? And then an ad hoc committee is formed, and you are being told, come and give your views, that you can influence the process. Two, we take the view that we will not participate in this because the timing for these amendments is wrong. You cannot change the rules of the game at halftime. We use the same rules for 90 minutes. After that, we review the process. How do we need to improve our electoral system for purposes of the next election? What Jubilee is doing is reactionary, to try and legislate in such a way that if there was a contest over the results of the 26th October, that no court will have the legal basis to nullify such an election. But secondly, he talked of the chairman of IEBC having filed a petition to seek interpretation. One, I'm not aware of any such petition. And two, the things he's saying that the chairman is seeking clarification were already clarified, actually in the same Maina Kiai case. And the reason why there was an appeal to the Maina Kiai case in the Court of Appeal was because the Commission wanted clarity on the decisions that the High Court had made, and those clarities were provided. And the Commission issued a public statement that now they have got clarifications and they don't intend to pursue that case any further. So I'm not aware of any case, and I don't think there is a case. Otherwise, when we met them on Tuesday, they would have disclosed that they have filed a constitutional reference for interpretation.
Right, there's still a lot more to talk about on Citizen Extra. Keep watching. We're taking a short break now. After the break, the discussion continues. Plus, we cross over now to County Hall, where the proceedings will be going on. That is submissions to the Joint Select Committee, the proposed changes to the election laws. Stay tuned.
Occasions bring Kenyans together. Few as massive as the agricultural show of Kenya.
It's a perfect place where all Kenyans unite to celebrate and showcase the diverse blessings of this country.
So join us this Sunday morning as we extend this celebration on Roka. We kick off at 6 a.m. all the way through to 9 a.m. only on Citizen TV.
Join us at the Nairobi ASK Showground for an interdenominational church service from Seatam Church, the Catholic Church and ACK Church with the theme One People, One Nation, One Kenya.
Campus tours zimeshika mbaya sana, si ndio? It's only right tukwe na ka holiday, si ndio? Au sio? Sawa manze.
So unatupeleka?
Wacha tuende showground. Showground.
Hizi zingekuwa segment za Bambika, zingekuwa nini? Hivi ndio naangalia hii ni world check. Hii na kaiko na saiki, hii ni jibambe hii. Hii ni talanta mtaani.
So join us this Sunday for Bambika, coming to you live from ASK Showground. Why don't you join us for a fantastic show starting from 11 a.m. to 1